9-0. Every single justice on the United States Supreme Court agreed, not 5-4, not 6-3, 9-0. And the decision they just handed down is already sending shockwaves through every courthouse, every state legislature, and every law enforcement agency in all 50 states. This is the Supreme Court's 9-0 decision that is reshaping Second Amendment rights across America, and the fact that most Americans are hearing about it for the first time right now, not from their local news, not from the cable networks, not from their elected officials, tells you everything you need to know about how broken our information system has become. If you own a firearm, carry a firearm, or have ever thought about purchasing one, this ruling is not abstract. It is not a legal technicality buried in footnotes. It reaches directly into your life, your rights, and your future. If this channel has ever given you information that the mainstream media refused to, now is the time to hit that subscribe button and turn on notifications. We are at a moment where legal changes are accelerating faster than most Americans can track, and the people who stay informed are the ones who stay protected. Subscribe right now, because what comes next in this video is exactly the kind of information that powerful people would prefer you never fully understand. Here is the foundation you need. For years, decades actually, the fight over the Second Amendment played out in a predictable pattern. State governments would pass gun restrictions, gun rights advocates would sue, courts would weigh the government's interest in public safety against an individual's constitutional right to bear arms. And more often than not, the courts would side with the government, using what legal scholars call interest balancing, essentially a judicial shrug that said, well, public safety is really important, so we'll let this restriction slide. That system allowed thousands of gun laws to pile up across the country without ever truly being tested against the actual text of the Constitution or the history behind it. Gun owners were told to comply first and litigate later, and most of them never had the resources to fight back. That era is now over. In 2022, the Supreme Court issued its landmark ruling in New York State Rifle and Pistol Association versus Bruen, and it fundamentally changed the legal landscape. The court said plainly that the old interest balancing approach was wrong. It said that when courts evaluate a gun law, they cannot simply weigh competing interests and pick a winner. Instead, they must apply what became known as the historical tradition test. The question is no longer whether a gun law seems reasonable or whether a government official believes it serves public safety. The question is whether that law is consistent with America's historical tradition of firearm regulation, specifically, traditions that existed at or around the time the Second Amendment was ratified. That was a seismic shift, but what just happened in March of 2026 takes that shift and amplifies it in ways that most legal analysts are still scrambling to process. The new 9-0 ruling, unanimous, remember, every single justice in agreement, came out of a case that began in a single state, but now applies with full force to every state, every territory, and every jurisdiction in this country. The specific defendant in this case was charged under a state gun law for firearm possession. The details of that individual case matter less than what the court said about how such charges must be evaluated going forward. The court ruled, without a single dissenting voice, that when states create and enforce gun laws, they must rigorously satisfy the constitutional standard established in Bruen. They cannot cut corners. They cannot rely on vague appeals to public safety. They cannot assume their laws are constitutional simply because legislators voted for them or governors signed them. Every gun law, existing and future, must now survive a strict historical test, and if it cannot, it is unconstitutional. Full stop. Think about what that means in practice. We are not talking about a handful of obscure laws in 1 or 2 states. We are talking about thousands of laws currently on the books in all 50 states. Laws that were passed without ever being seriously evaluated against the historical tradition standard. Laws that assumed the old interest balancing framework would protect them from challenge. Those laws are now exposed, and the gun rights organizations, the Second Amendment Foundation, the Firearms Policy Coalition, and dozens of state-level groups have been preparing for exactly this moment. Their legal teams are already identifying targets. Their attorneys are already drafting complaints. The litigation wave that is about to crash over this country is going to be unlike anything we have seen in the history of Second Amendment jurisprudence. Now let's go deeper on the historical test itself, because this is where the real power of this decision lives, and it's also where the government's biggest vulnerability is exposed. When a court now examines a gun law under this framework, it must answer two questions in sequence. First, does the Second Amendment's plain text cover the conduct being regulated? In other words, is the person doing something that falls within the core protection of the Second Amendment? Keeping a firearm, bearing a firearm, possessing a firearm in their home or in public? The answer to that first question is almost always yes, because the Second Amendment is written broadly, and the Supreme Court has consistently held that law-abiding citizens have the right to keep and bear arms for self-defense. So that first hurdle almost always clears automatically in favor of the gun owner. The second question is where the government gets put on trial. Is there a historical tradition of regulating the conduct in question? And not just any historical tradition. The tradition has to trace back to the era of the founding, to the late 1700s and the early 1800s, when the Second Amendment was written and ratified. The government has to go into historical archives and find laws, actual laws, that are analogous to the modern restriction they're trying to defend. Not laws that kind of look similar if you squint. Not philosophical arguments about what the founders might have approved of. Actual historical laws that demonstrate a genuine tradition of regulation. And here is the devastating truth that state attorneys general and their legal teams are now waking up to in a cold sweat. Most of them cannot do it. Most of the modern gun restrictions that have been piling up in blue states and even some red states over the past several decades have no genuine historical analog. They were invented in the modern era to address modern anxieties, and they were passed under the assumption that courts would defer to the government's judgment. That assumption is gone. Consider a specific example that millions of Americans encounter directly. Imagine your state has a law prohibiting the carrying of a firearm in a public park. On the surface, that sounds reasonable to a lot of people. Parks are public spaces. Families go there with children, so the argument for the restriction is emotionally intuitive. But intuition is not the legal standard anymore. The question is whether there were laws in 1791 or thereabouts that prohibited Americans from carrying firearms in public parks. And the honest answer, when you actually dig into the historical record, is that no such tradition exists in any meaningful, documented form. People in the founding era carried firearms openly and regularly in public spaces of all kinds. They did not carve out parks as gun-free zones. They did not require permits. They did not demand proof of special need. The modern park carry ban, when subjected to the historical tradition test, does not survive. It is the kind of law that gun rights attorneys are now lining up to challenge, and under this new 9-0 ruling, they have the strongest legal ammunition they have ever had. Here's another example that hits even closer to home for millions of gun owners who live in heavily regulated states. Many states, California, New York, New Jersey, Maryland, Massachusetts, and others, have long required applicants for concealed carry permits to demonstrate what they call good cause or justifiable need. In plain language, that means you had to convince a government official that you personally had a special reason to carry a firearm. Not that you were a law-abiding citizen who wanted to exercise a constitutional right. You had to prove you were somehow more deserving of that right than your neighbor. The Bruen decision in 2022 already dealt a significant blow to that kind of requirement, declaring it unconstitutional. But some states found ways to slow-walk compliance, to find new bureaucratic mechanisms to delay or effectively deny permits even after Bruen. The 9-0 ruling now slams that door shut with the full weight of a unanimous Supreme Court behind it. You cannot make Americans beg for a constitutional right. You cannot create a permission structure so burdensome, so discretionary, and so gate-kept by government officials that the right effectively disappears. The court has said it again, and this time every single justice agreed. Right now, in the weeks and months following this decision, the states with the strictest gun laws are scrambling. Their attorneys are being asked to audit their entire gun law frameworks and identify which laws can survive the historical test and which ones cannot. And the honest ones, the ones who are being straight with their clients rather than telling politicians what they want to hear, are coming back with uncomfortable answers. Assault weapon bans, which prohibit entire categories of commonly owned firearms, are facing serious constitutional questions. Magazine capacity limits, which restrict how many rounds a firearm can hold, have already been successfully challenged in multiple courts and are now even more vulnerable. Red flag laws, which allow courts to temporarily confiscate firearms from individuals without a full criminal trial, are being examined under the historical tradition standard, and the historical support for that kind of pre-crime seizure is thin at best. Restrictions on carrying firearms near schools, on public transit, in restaurants that serve alcohol, in parking lots, and in dozens of other locations are all now subject to challenge. This is the moment where a lot of people watching will think, okay, so does this mean all gun laws are going away? And the answer to that is no, but not for the reasons anti-gun politicians will try to tell you. The Supreme Court has been clear that certain restrictions on firearms are constitutionally permissible, and the reason they're permissible is that they do have historical roots. Laws prohibiting felons from possessing firearms, for example, have historical support. The founding era did recognize that certain individuals, those who had committed serious crimes against society, could lose the right to bear arms. Laws prohibiting firearms in certain genuinely sensitive places like courthouses and legislative chambers also have historical support. The founders understood that some specific government functions required an environment free of armed confrontation. Those restrictions can survive the test. But the key word is genuinely. States cannot simply declare any location a sensitive place to manufacture a constitutional exception. They cannot invent new categories of prohibited persons and attach them to the historical tradition without actual historical evidence. The court has been explicit about this, and the 9-0 ruling reinforces it with a clarity that is impossible to misread. If you are still watching this, you understand by now that this ruling matters. What I need you to do is share this video with every gun owner you know. Drop a comment below telling me what state you live in and what specific gun laws you believe need to be challenged under this new ruling, and make sure you are subscribed with notifications turned on. The next several months are going to bring legal developments faster than almost any channel is going to be able to keep up with, and your engagement here directly shapes what we cover next. Gun owners in states like California and New York especially, your input is critical. Comment right now. Now let's examine what this ruling does to the people who have the power to put you in handcuffs and in a courtroom. Because this is the part of the 9-0 decision that is getting almost no attention, and it deserves to be front and center. Prosecutors, state and local, who charge individuals with gun crimes now carry a significantly heavier burden than they did before. It is no longer enough to point to a law, show that a defendant violated it, and expect a conviction. The constitutionality of the law itself is now a live question in every gun case. Defense attorneys are going to challenge the historical validity of the laws their clients are charged under, and in many cases, those challenges are going to succeed. Cases that previously seemed like easy convictions for the government are going to get complicated, charges are going to get dropped, cases are going to get dismissed. Some people who were convicted under laws that cannot survive the historical test are going to have grounds for appeal. This is not a loophole. This is the Constitution doing exactly what it was designed to do, restraining government overreach and protecting individual rights. For decades, the system tilted so far toward government power in gun cases that ordinary Americans, people who made honest mistakes, people who misunderstood the law, People who were caught in the crosshairs of overzealous prosecutors paid an enormous price. They lost their firearms, they faced criminal charges. In some cases, they went to prison, under laws that the Supreme Court is now telling us should never have been enforced in the first place. The outrage here is not theoretical. The damage was real. The lives affected were real. And the accountability for the politicians and prosecutors who built and enforced this unconstitutional framework needs to be real as well. Let's also address the judges, the federal and state judges who, for years, used the interest-balancing approach to uphold gun restrictions even when those restrictions had dubious constitutional foundations. The Supreme Court has now told those judges, explicitly and unanimously, that their methodology was wrong, that what they were doing was not legal analysis, it was judicial preference dressed up in legal language. Some of those judges resisted Bruen. They tried to find workarounds. They applied the historical tradition test in narrow, government-friendly ways that essentially preserved the restrictions they personally believed were good policy. The 9-0 ruling forecloses that kind of judicial activism. When every single justice on the court agrees on the standard, there is no ambiguity left for lower court judges to exploit. The test is the test. Apply it honestly or face reversal. And what about the politicians? What about the state legislators and governors who spent years building these gun restriction frameworks and told their constituents they were doing the right thing, that they were making communities safer, that they were being responsible? Some of them genuinely believed that. Some of them were doing the cynical political calculus of an anti-gun base that rewards restrictions regardless of their constitutional validity. But all of them now have to reckon with the fact that the laws they championed, the laws they celebrated at press conferences and campaign rallies, may be unconstitutional. Some of those laws are going to be struck down. Some of the communities that were told they were being protected are going to find out they were being misled. That is not a comfortable truth, but it is the truth. Here is what you need to do right now, and I mean right now, not next week. Not after the next news cycle pulls your attention somewhere else. If you live in a state with strict gun laws and you have been denied a permit, had a permit application delayed without justification, or been told you cannot carry in places you believe the historical record does not support restricting, you need to contact a firearms attorney in your state. This ruling gives those attorneys a powerful new weapon to fight for your rights, and the sooner you start that conversation, the better positioned you are to benefit from the legal challenges that are already being filed. Do not assume that because a law is on the books, it is constitutional. The Supreme Court has just told you unanimously that many of those laws are not. If you are not currently facing a legal issue, but you want to stay on the right side of this rapidly changing legal landscape, the most important thing you can do is stay educated. Follow the cases being filed by the Second Amendment Foundation and the Firearms Policy Coalition. Pay attention to rulings in your federal circuit. Know which laws in your state are being challenged and where those challenges stand. The legal terrain is shifting under everyone's feet right now in 2026, and the gun owner who knows the law is in a fundamentally different position than the gun owner who doesn't. Knowledge here is not academic. It is practical. It is the difference between knowing your rights and inadvertently surrendering them. Now, let me be completely straight with you about what is coming next, because anyone who tells you this ruling ends the fight is either naive or deliberately misleading you. The political machine that has been driving gun restriction legislation for the past 3 decades is not going to look at this 9-0 decision and quietly pack up its operation. It is already retooling. Right now, in state capitals and in Washington, attorneys and policy advisors working for gun control advocacy organizations are combing through historical archives looking for any precedent, any statute, any regulation, any court ruling from the 1700s or 1800s that they can use to build a historical defense for the laws they most want to protect. Some of them will find thin reeds of historical support and argue loudly that it is enough. Some state legislatures are going to respond to this ruling by trying to craft new laws that they believe are designed to pass the historical test. Laws that are written with the explicit goal of surviving constitutional scrutiny while still achieving the practical effect of restricting gun rights. This is the next phase of the battle, and it is already beginning. That is why the 9-0 ruling, as powerful as it is a battle won, not the war ended. The Second Amendment has always required active defense. It has always required citizens who understand it, believe in it, and fight for it through legal channels. The court has handed gun rights advocates the most powerful legal tool they have ever had. But a tool only does work when someone picks it up and uses it. The lawsuits being filed right now, the challenges moving through the courts right now, the attorneys arguing in front of federal judges right now, that is where the rubber meets the road, and every gun owner in America has a stake in how those cases turn out. Do not let this moment pass without doing something with it. Subscribe to this channel right now, turn on your notifications, and be here when we break down the specific lawsuits that are already being filed in the wake of this ruling. State by state, law by law. Drop your state in the comments below and tell me which gun laws you want to see go down. Tell me what your experience has been trying to exercise your rights in your state. Your voice shapes this coverage, and your comment takes 10 seconds but matters enormously. This is a community of people who take their constitutional rights seriously, and that community grows stronger every time one more informed American joins it. The mainstream media is not going to give you this level of detail. Your local news is not going to walk you through the two-question historical test and explain why it dismantles decades of gun restriction law. That is what this channel exists to do, and the only way it keeps doing it is if you are here, engaged, and spreading the word to every gun owner you know. The bottom line, stated as plainly as it can be stated, the Supreme Court of the United States, with every single justice in agreement, has handed down a ruling that fundamentally strengthens your Second Amendment rights, strips the government of its most commonly used justification for gun restrictions, and opens the door to the most significant wave of pro-gun litigation this country has ever seen. This is not spin. This is not wishful thinking. This is what the ruling says and what the legal community, across the ideological spectrum, understands it to mean. The fight is not over, but the ground has shifted decisively, and it has shifted in favor of law-abiding American gun owners who have spent decades being told to sit down, comply, and trust the government to know what is best for them. The Supreme Court, unanimously, has just said the government does not always know best, and the Constitution says so. Now it is your job to know that, act on it, and never let anyone take it from you.